Let's move to what I know you're working on a piece for the American Prospect on
Hmm.
and there certainly seems in the past 2 weeks as much activity coming out of the Department of Justice in terms of at least there's activity, there's kinetic activity, as the
Yeah.
administration likes to say, regarding holding Wall Street accountable to some degree. And by that I mean 2 weeks ago there was a Frontline documentary recounting the failure of the Department of Justice not just to prosecute any of the fraud that took place in the and resulted in the financial meltdown, but what apparently was very clear in this film, there was a significant lack, if that's a way of phrasing it, of even investigation into it. I mean, and it
Oh,
followed with Lenny Brewer having to resign, move on, spend more time with his family, I guess, or more time sort of defending the people that he was not prosecuting in his capacity at Department of Justice. Then we see today the announcement that there was going to be a suit against S&P, and also Elizabeth Warren and Elijah Cummings sent a letter
hmm.
to the Fed and the comptroller of the currency, looking to
Yeah.
documents, looking for documents that were relating to the recent settlement with mortgage servicers. Talk to us about that.
Okay. First of all, I do think the Frontline documentary really raised the attention on this issue, even though it focused on just one segment of the fraud that was perpetrated throughout the financial crisis, basically on mortgage fraud, on origination, and not really anything else. It highlighted the nature of the problem, that the Justice Department was more concerned about the financial health of the banks, frankly, than actually upholding the rule of law. And this is something that, was very surprising to people, that it even comes into play on the part of the Justice Department. You would expect maybe the Treasury Department to have these kinds of reservations, but the idea that the top law enforcement agency in the country is debating the financial health of various firms regarding prosecutions is extremely troubling, especially because when you're talking about criminal prosecutions of top executives who organized and authorized these fraudulent activities, it's not like they're irreplaceable and that this would cause a bank to go insolvent suddenly if they don't have a criminal at the top of the food chain in their organization. So I do think that played a role in sort of this activity that you're seeing. With respect to the S&P suit, it's interesting because they are using a couple different kinds of statutes to get at this inherent conflict of interest issue regarding the credit rating agencies. I mean, the rating agencies are paid by the issuers of the securities, and the more ratings that they issue, the more money they get. And obviously, that means they don't want to really piss off their cash cow, which is the people who are issuing these securities, who are the big banks, who want good ratings for their products so they'll be purchased. So that inherent conflict of interest issue is really at issue in this lawsuit. Now, S&P has, in the past, used basically, believe it or not, First Amendment grounds to say that they were just issuing journalistic opinions that were only meant for small groups of people and investors, and they have a First Amendment right to offer their opinions on the ratings of these products, and that has been accepted in some cases by courts. The other thing is that in order to get sort of accreditation to be a rating agency, a nationally recognized statistical rating agency, Congress, through statutes going back decades, has given them a certain amount of protections. So it's going to be difficult for this lawsuit to actually succeed. They're using some novel statutes in terms of basically arguing that the investors were not informed of the conflict of interest issue, or they were told that that these were independent and objective ratings that were not compromised by conflict of interest. And they're also using FERIA, which is a federal law that has a longer statute of limitations and a little more leeway in terms of getting at some of these things. So we'll see what happens. Apparently, there was a settlement that was being offered, and it kind of broke down because DOJ actually wanted S&P to admit wrongdoing, which is novel for the last few years of the financial crisis. Often these settlements come by with neither an admission or denial of wrongdoing.
So what do you make of this? Now, I know that there's still floating around out there is the Franken Amendment to the Dodd-Frank Act, the Dodd-Frank bill. And the Franken Amendment, if I'm not mistaken, would say essentially that the SEC, I don't know if it was the SEC, but it would essentially take away the opportunity for a firm, the issuer of a bond, essentially, it would take away their ability to choose which agency would rate it. In other words, they would, I guess it would be an independent agency which would assign a rating agency to that product, which would, at the very least, lessen the conflict of interest, because if I'm not in charge of hiring who determines the value of my goods, then I can't really punish them for saying that my goods are not valuable.
Yeah, it would change the issuer pays model. It would turn it into this randomized assignment of ratings to these nationally recognized statistical rating agencies, and it would also increase your business based on your quality of your ratings. Every year you would sort of look back and see
You'd get a report
securities
card.
did, and you would get more ratings or more products to rate based on whether you were right about the various securities. So that would obviously be a great model. The problem is that Dodd-Frank didn't mandate that. They made it as part of a study to study whether there were better models out there other than the issuer pays model. And there have been reports that have been issued, but it's unclear whether there's going to be a movement forward and actually to change the model. I mean, one thing that a lawsuit like this could do, and certainly it could have done if it was put out before the Dodd-Frank law, is to highlight this conflict of interest and say that we need to overhaul this system. I'm not sure, coming years after Dodd-Frank and years after the regulatory reform, that we're going to get that much traction on it. Even if the lawsuit succeeds, we'll have to see. But it shows the value, sort of, to the banks and the rating agencies and Wall Street of the delays, if not outright just dropping the ball on these prosecutions, because it neuters the ability for changes either legislatively or through the regulators to actually change fix the problems that were there.
Well, so what do you make of what do you make of this in both why Standard & Poor's as opposed to Moody's or other rating agencies that were just as horrible, if not worse, in many respects?
Sure.
And why now? I mean, the timing of this seems. Are we seeing is this a function of the president, of the administration having a different disposition? Is it a function of the fact that we are supposedly further away from the wake of the financial crisis, and now there's we can afford to actually apply the law to these people? Is it a function of the perhaps a renewed sense of oversight by certain senators? I mean, what is this a function of?
I would hope that it reflects on the part of the Obama administration to really get at this and to be less concerned with the idea that prosecuting crimes and upholding the rule of law will knock down the financial system, and having that paramount as your primary concern. I'm not sure that that's the case. The other thing is that the Justice Department did put together this case against Bear Stearns, against a specific criminal case against specific traders at Bear Stearns who were accused of securitization fraud, basically, against investors, and the jury acquitted them. And ever since then, they've been really gun-shy to prosecute these cases with the possibility that they could lose the cases. And that has driven a lot of the hesitancy, I think, at the Justice Department, that they're kind of inside their own head. They don't believe that they can get a conviction on some of these cases. Now, it's important to recognize that the S&P case, first of all, is just the one rating agency, as you said, and second of all, is a civil case.
Right.
It's not a criminal case.
And there's a lower bar of proof necessary.
Yes, it does force them to admit wrongdoing, which would bring up a whole host of private litigation as investors who, any investor who bought a product rated by S&P could say, you admitted wrongdoing or you were convicted of a crime in terms of these securities. That means you were also convicted, you're also guilty in terms of my securities and I want money. So it would be a big problem, and rating agencies aren't necessarily as lucrative as Wall Street banks, and so it would be a pretty existential problem for S&P if this goes the way of the Justice Department wants, or it could be at least.
It's just so shocking. It's just so shocking to see this. I mean, we're 2 months out from HSBC, maybe less than 2 months now. I've lost track of time. Where the Justice Department said, yeah, they did some money laundering, billions of dollars for drug cartels, but come on now. I mean, if we were to arrest anybody involved in this would be problematic for the financial system. Yet we're seeing some...
The rating agencies are still a small fish.
Right.
I mean, this is not going after a major Wall Street firm who issued the securities and was complicit, presumably, in the conflict of interest, in that they were the ones pressuring S&P and the other rating agencies to give them good ratings with the carrot of, we'll give you more business. So no one's prosecuting that right now. We're talking about a civil suit against S&P for their conflict of interest. And I don't have a problem with sort of, going after this at all angles. But ultimately, this is a small scalp to collect. I'm glad that they're going after it, and maybe they'll get the confidence if this case does go through that they can secure convictions on these fronts, and that this activity was fraudulent and that it needs to be investigated and prosecuted.
How seriously are you taking, in a semi-related note, this attempt by Senator Warren and Representative Cummings to review the foreclosure review process, which led to this mortgage settlement 6 months ago, I guess?
Sure. Yeah. I'm taking it fairly seriously. I mean, this is really Senator Warren's first sort of step up to the plate. And it's one of her first actions, and this is just a month into her tenure. And what is she going after? She's looking at this foreclosure review. And what happened was, just to give a little background, is that the OCC, Office of Comptroller of the Currency, and the Federal Reserve sort of broke off from the major global settlement process with the state AGs on these foreclosure abuses, robo-signing, and all of the various servicer abuses against homeowners. They broke off in April of 2011 and said, here's what we're going to do. We are going to take every foreclosure that happened, every borrower in foreclosure in 2009 and 2010, we're going to give all those people the opportunity to sign up for a review of their file. And this review of their file will see if there were errors in the process, will be comprehensive, and if there were errors, they will be remediated by the big servicers who are the big banks. So it turns out that these are supposed to be independent reviews, what happened is that the banks actually paid the independent reviewers and handpicked the independent reviewers, who were these bank consultants. And numerous whistleblowers have come forward to say that this was a farce of a process, that
I'm shocked.
Independent reviewers, yes, they were not independent, and they were not even reviews. The banks would actually give filled-in sheets for what they did in each case, in each borrower file, and all that the independent reviewers were to do was to sort of check the work that was already done by the banks. And needless to say, the banks had an interest in not showing a lot of errors on their part. There were also allegations that they pushed back, the banks pushed back, and the reviewers, the consulting firms, pushed back on any errors that were shown at the ground level by the specific reviewers who were temps. They were entry-level people who were, they didn't have expertise in mortgages or foreclosure operations. And so after a while, the OCC and the Fed said, well, we can't really show this work, what was done, because it's clearly farcical. So they entered into this settlement. They threw out, and there were 500,000 reviews, and they threw them out and said, okay, now here's a pot of money, and the 3.8 million borrowers who were in foreclosure from 2009 to 2010 will split $3.3 billion. That's less than $1,000 per foreclosure, and it won't be based on whether there were errors in specific cases. It will just be, well, your loan looks like this, so we'll give you $250, and your loan looks like this, so we'll give you $500, and so on. So what Warren and Cummings are looking for is the actual any performance reviews put together by OCC and the Fed. They're looking for how much money was delivered to these independent bank consultants. They're looking for specific metrics and statistics on how many errors were found, how much money was supposed to be dished out in terms of the errors that were found. And basically, they're looking to liberate this data. I mean, it was a flawed process, but there's 500,000 borrower files that were looked at by independent reviewers, nominally independent reviewers, and there were errors found. We know that there were errors found. The whistleblowers say there were massive amounts of errors found, and Warren and Cummings want to see it. They want to see the data. Too many times we've seen in the last few years with these bank abuses is that the settlement talks begin before the investigation even. Right. And the regulators say, well, we have no leverage because we don't know exactly what was the harm was, and we entered into the settlement and made sort of an eyeball guess of what the actual harm was, and then the banks pay it off, and that's the end of it. Well, here's the leverage. There are 500,000 borrower reviews that are sitting there, and I don't know how you can regulate the mortgage servicing industry. I don't know how you can look at the regulators themselves and whether they're doing a good job unless you see the raw data. And so much like she did at the Congressional Oversight Panel that was overseeing TARP, much like she did standing up the Consumer Financial Protection Bureau, Senator Warren is trying to liberate this data and put it to use on behalf of the middle class, particularly those who've been hammered by unscrupulous financial institutions who've been ripping them off.
Well, that's encouraging. I mean, it sounds a little bit like we had a fraudulent process that was supposed to investigate the fraud that took place. And by the end, you get sort of this illusory, I guess, resolution of it, but they're hoping to crack it back open, and at the
I'm not terribly optimistic they're going to crack it back open, but it's good for Warren just to put her name to this, I think, and just to sort of put some ground out there that she's actually going to stand up for these interests. She's not going to take the tactic of just sort of putting her head down and building relationships in the Senate. She's going to throw some elbows, and she's going to highlight these issues. And because she has such a following behind her, the prospect of her, rather than Elijah Cummings or Maxine Waters, who've been at this for a long time, they don't necessarily have the kind of microphone that an Elizabeth Warren has to highlight this kind of issue and turn it into something that has some momentum.
And any pressure that is put on the entire mechanism that has been looking over our financial system, I think, is going to bear fruit. There may not be a direct correlation, but if she's out there and making it clear that she's going to push for more transparency, for some more legitimacy in any of these processes, it has to raise the game of all these processes.
One would hope.
Yes.
Certainly.
Indeed. Well, David Dayen, always a pleasure, and great to see you out there writing. And we will link to the TNR piece on the California comeback, and look forward to your American Prospect piece on that issue of the review that we were just talking about. So thanks so much for joining us.